Hi, Phil the Engineer back at you again. In my last video I talked about the 4 R's of healthcare cost: research, regulatory, reimbursement, and risk. Today I will talk about how the regulation imposed by the Health Insurance Affordability and Accountability Act of 1996, also known as HIPAA, has increased the cost of healthcare with no value add. The following is a quote from the America's Healthy Futures Act of 2009. This is a healthcare bill currently under review in the Senate Finance Committee. The Federal Health Insurance Portability and Accountability Act of 1996 established federal rules regarding guaranteed availability, guaranteed renewability, and coverage of pre-existing conditions in the individual market for certain persons eligible for HIPAA requirements. HIPAA guarantees that each issuer in the individual market make at least 2 policies available to all HIPAA-eligible individuals, and renewal of individual coverage is at the option of such individuals, with some exceptions. So a law has been in place since 1996 guaranteeing coverage for pre-existing conditions. But of course, since costs were not capped, premiums could be increased to the point where they are unaffordable. But the part of the law that was most onerous had to do with so-called protection of your health information. This quote from the Act also sums up the requirement for privacy. The HIPAA security standards specify certain administrative, physical, and technical measures to safeguard health information in an electronic form against authorized use and disclosure. And then also from the Department of Health and Human Services website, this quote gives you a warm fuzzy for what the government is doing for you. The privacy rule provides federal protections for personal health information covered by entities and gives patients an array of rights with respect to that information. At the same time, the privacy is balanced so that it permits the disclosure of health information needed for patient care and other important purposes. Now for what they don't tell you. The balance clause, as I like to put it, means that health information may be shared without your consent with organizations or individuals that participate in your care. This includes insurance companies, physicians, hospitals, as well as many government agencies. However, information may not be shared with family members unless you give written consent. So let's walk through an example. You're brought into an emergency room unconscious via ambulance. Your spouse is contacted and informed that they brought you in. Your health insurance company is contacted, given your medical status and the authorized treatment. Your spouse arrives but cannot be apprised of your medical condition because you have not signed a HIPAA release form. Under penalty of law, the physician or hospital cannot release this information without your consent. So the already paranoid hospitals and physicians concerned about malpractice now have to worry about obscure disclosure laws. It makes no sense. I'm sure that you're saying, they must be wrong. This makes no sense. So I invite you to go to the HHS website and do a search on HIPAA, HIPAA, and read the information for yourself. This has made one world-renowned research hospital in this area so paranoid that you take a ticket from a machine when you arrive for an appointment. When your number is called, you're asked for your ID card so that they can register you. Your name is never spoken. Is this an improvement in quality of health care? I don't think so. It's an idiotic waste of money. As another example, suppose your employer is shopping for new health plans. Any clerk in an insurance company can get access to your medical records without your consent so that the premium computations can be made for your employer. The health information cannot be shared with your employer, but the fact is that insurance companies get access to your information without your consent, but your spouse can't. But this onerous and useless law affects not only the practice of medicine, but also research. So if a researcher wants to discuss the results of a study with a colleague who is not part of this study, this cannot be done unless the data is de-identified using arcane rules established by DHHS. Bills are currently in Congress establishing national registries for Parkinson's and MS. The health care bill proposes registries for all chronic illnesses. The intent is to get real numbers instead of estimates on how many people in the U.S. actually suffer from these diseases. This allows makers of medical products to better assess the market for their products and encourages them to invest in research. It also helps establish national priorities for government investment in research. But these registries are incongruent with HIPAA, since it does not even allow the use of zip code in de-identified data. When I conducted medical research, I was required to take 8 hours of training on HIPAA and the arcane rules for de-identification of data. What value add is this? So we can save money and expedite research by getting rid of the onerous HIPAA privacy requirements. We certainly don't need to have our health information protected from our family. I trust that hospitals and physicians will be discreet in the release of medical information the same as they were before the passage of this goofy law. We don't need research dollars wasted on compliance with arcane rules. If you are participating in a protocol, you most likely want your data shared. We don't need a bureaucracy in DHS looking over everyone's shoulder. We also don't need a horde of administrative people running around burning up our healthcare dollars getting consent forms signed. Besides, it is only an illusion of privacy. Health insurance companies and many government agencies have free access to your information without your consent. If information gets leaked, they would be the most likely entity to leak it. So write your congressman and tell them to get rid of the onerous and useless HIPAA privacy laws. This is a painless way to save money. This is your money. Don't let the clunkheads in Congress raise taxes for health care before they take steps to get goofy laws like HIPAA privacy off the books. Once again, I thank you for your time.